Senator from Oregon.
President, I've come to the floor today to discuss the nomination of William Barr to be Attorney General. And today I want to make clear that I will be opposed to this nomination for several reasons. I'm just going to outline some of my key concerns that really haven't been much addressed over the last few weeks. I'm specifically concerned about his view that the President of the United States is effectively royalty in his book. And he seems to believe that the President is unaccountable to the laws of our nation or to the normal constraints imposed by the Congress. So today I'm going to focus on what I consider to be Mr. Barr's dangerous views on surveillance and his contempt for surveillance law and the Fourth Amendment. It's my view that this is not a partisan issue. There has been for some years a bipartisan coalition here in the Senate that has battled to protect the privacy and constitutional rights of Americans. But Mr. Barr's views, after I've laid them out today, ought to frighten every member of this Senate. What Mr. Barr has said, whether the Congress supports broader or narrower surveillance authorities, and regardless of whether Congress votes for more checks and balances and oversight, Mr. Barr has said it really doesn't matter. He has made that judgment based on the proposition, which he has stated very clearly, that the President can essentially do what he wants. This nominee, in my view, poses a unique threat to the rule of law and the Fourth Amendment. His long-held views, which presumably he would put in practice if confirmed, threaten the very notion that the Congress or the courts have any say on who in America gets spied on. If he's confirmed as Attorney General, he could take us back, and not just 12 years, to an era of warrantless wiretapping. As Mr. Barr himself has made clear, he would be taking us back to 40 years, to an era before the Church Committee, when neither the Congress nor the courts had any role at all in checking or overseeing an abusive, out-of-control government. Before the reforms of the 1970s, as has now been well documented, the government committed one horrific abuse after another. It spied on hundreds of thousands of innocent Americans. It spied on Dr. Martin Luther King Jr. It spied on activists. It spied on Congress. And when the abuses finally came to light, the Congress acted by passing the Foreign Intelligence Surveillance Act, which established a secret court to issue warrants against spies and terrorists. Unfortunately, as we now know, the government violated the law when it implemented its warrantless wiretapping program in 2001. The program included warrantless collection of the content of private communications, including through warrantless targeting of phone numbers and email addresses of people here in our country. The program also included the bulk collection of phone and email records of enormous numbers of innocent, law-abiding Americans. All of this occurred in secret, without warrants or any judicial oversight at all. And almost no one in the Congress nor even most members of the intelligence committees knew anything about it. The secrecy didn't even end when the bulk phone and email record programs were moved under the Foreign Intelligence Surveillance Act. The Obama administration, just like the Bush administration, kept the abusive program and the secret legal interpretations behind it from the American people, even lying about it in public testimony. How did these abusive and illegal programs get their start? With secret determinations made at the Department of Justice that the law didn't matter and that the president can do what he wants. So that brings us to Mr. Barr. His dangerous views on executive power have long been consistent throughout his career, from his writings at the Department of Justice in the late 1980s to the present. In October of 2003, he laid out in public testimony his position that in Mr. Barr's view, the president is not accountable to surveillance laws and that the president enjoys huge loopholes in the Fourth Amendment. October 2003 was shortly after the Congress had passed the Patriot Act, legislation that many in Congress have come to view as granting too much authority with too little oversight. From Mr. Barr's perspective, the Patriot Act was too limiting, too constraining, and that wasn't even the most troubling part of his testimony. Right up front, he asked himself the question of whether the law was adequate to fight terrorism. Here's what he said. He said he wasn't worried about the law, and this is a direct quote, "The critical legal powers are granted directly by the Constitution, not by congressional enactments." In other words, Mr. Barr's view of surveillance is that the laws passed by the Congress do not matter. The president wants to violate them. It's Mr. Barr's position that he can just go out and say he's got constitutional authority to do it. Here's a direct quote from Mr. Barr's testimony talking about laws going back to the 70s. He said, and I quote, "Numerous statutes were passed, such as the Foreign Intelligence Surveillance Act, that purport to supplant presidential discretion with congressionally crafted schemes whereby judges become the arbiter of national security decisions." So I'm going to unpack that sentence for a minute. From Mr. Barr's perspective, decades of laws passed by the United States Congress are nothing but schemes. Schemes. He's talking about the Foreign Intelligence Surveillance Act, the fundamental framework of checks and balances that Congress has relied on for 4 decades to ensure congressional and judicial oversight of surveillance. He's talking about every modification of the Foreign Intelligence Surveillance Act, from the Patriot Act to what's called Section 702, reauthorized last year, to the Freedom Act, which was intended to stop the collection of millions of innocent Americans' phone records. Whatever you think of these statutes are how Congress determines the extent of the government's surveillance powers and exercises its responsibility to protect the rights of Americans. Mr. Barr, notwithstanding, these duly enacted laws of Congress are not mere schemes. Worse still, it's Mr. Barr's contention that all of these laws only purport to have any effect. The president says Mr. Barr has the discretion to ignore them. By definition, if you are saying that the president can just ignore the laws, in effect you're saying that's a position that is in favor of tyranny. This is as dangerous a position as I have heard in congressional testimony. is very similar to the language that was concocted in the Department of Justice to justify warrantless wiretapping. And these are the views that come from the man who might be Attorney General of the United States. Now, Mr. Barr is correct that the Foreign Intelligence Surveillance Act gives judges some say in when the government can spy on Americans. It is a secret system, one that greatly advantages the government and almost always precludes challenges from those who are spied on. The Foreign Intelligence Surveillance Act has been abused through secret interpretations of the law. But the Foreign Intelligence Surveillance Act does involve judges considering the Fourth Amendment rights of Americans. And that's what Mr. Barr objects to. Based on his own testimony, it is clear to me that Mr. Barr has fundamental problems with the Fourth Amendment, or at least its application to anything that the president might unilaterally decide involves national security. He believes that if the government determines there's a threat, there is no need to ask a judge for a warrant. The Fourth Amendment protects the right of the people to be secure against unreasonable searches and seizures unless there is a probable cause warrant. That's what the Constitution says. Mr. Barr, however, has found two very, very big loopholes in the Fourth Amendment. First, he insists that if the government decides that a foreigner in the United States is, a quote from Mr. Barr, apparently acting as a terrorist, then he or she is not one of the people and the government can just throw out the Fourth Amendment. Second, Mr. Barr argues that so long as the government says there's a threat, a warrantless search is not unreasonable and the warrant requirement of the Fourth Amendment doesn't apply. At the core of Mr. Barr's philosophy is that no one, not Congress and certainly not judges, has any business assessing the government's assertion about threats. Here's another quote from Mr. Barr. Quote, "These are assessments judges are not competent to make or responsible for making under the Constitution," unquote. Mr. President, for 40 years, the judges of the Foreign Intelligence Surveillance Act Court have been making these determinations. But from Mr. Barr's perspective, the courts are not competent to decide who gets spied on. Only the president gets that power. Now, some might ask whether Mr. Barr has had a change of heart, particularly since Congress has passed additional surveillance authorities since the years since his testimony. I hope that we see in the days ahead where he stands, whether he now believes that spying on Americans and people in the United States has to be consistent with the laws passed by Congress. But his 2003 testimony suggests that even new sweeping bipartisan laws that have passed wouldn't satisfy him. A little over a decade ago, Congress created Section 702 of the Foreign Intelligence Surveillance Act. That allows for warrantless spying on foreigners overseas. Now, Mr. President, I have said that our country faces real threats from foreigners overseas. So I stipulate that that's something that's important to the safety of the law-abiding people that we all represent. But I have had serious concerns about the number of innocent Americans whose communications are being swept up under Section 702 collection. But at least the targets for the surveillance are overseas. Mr. Barr would go further in his testimony, calling for the warrantless targeting of people inside the United States. According to Mr. Barr, there are individuals right here in the United States who have no Fourth Amendment rights. And Mr. President, this is an important issue today, and it will become more important in the days ahead. Now, I've already stipulated that I think there are serious threats to our country overseas. And what troubles me is that as telecommunication systems around the world become more globally interconnected, more and more innocent Americans are going to get swept up in these searches. And to me, when you're talking, as Mr. Barr seems to be doing, that there are individuals in our country who have no Fourth Amendment rights, that's why I think all senators should be troubled about these positions he has long espoused. There's also the matter of collecting business records, sensitive information about Americans that are in the possession of a third party. Now here, we're talking about your purchases. It's who you are communicating with. It's where you're located at any time of the day. Mr. Barr believes that the Fourth Amendment doesn't apply to any records held by a company or other third party, no matter how sensitive that information is. This view has actually been rejected recently by the United States Supreme Court. So what Mr. Barr has been saying is actually out of sync even with the current thinking at the Supreme Court. The Supreme Court most recently held that the Fourth Amendment did apply to government's collection of location data from wireless carriers. Apparently, yesterday, Mr. Barr said he had not read that Supreme Court decision. Colleagues, I think that ought to be really troubling to the members of this body. We're talking about location data. Location data can be a personal safety and national security nightmare. We saw what happened just last week. In 2018, the wireless companies all made promises to me that they wouldn't make available location data, precise location data, to hedge funds, bail bondsmen, all kinds of bottom feeders just looking to make a buck. And what happened was, in 2018, those wireless companies said that they wouldn't make that data any longer available to these location trackers and bail bondsmen and the like. And then last week, a bounty hunter got $300 and found out those 2018 promises to me meant nothing. So last week, the wireless companies promised again that they wouldn't make location data available to all of these financially interested parties. And I appreciate them saying it, but I'll tell you, I'll believe it when I see it, because we got a promise in 2018 that they would be serious about protecting location data, and we saw last week that they weren't. And you've got the Supreme Court now making it clear that the Fourth Amendment applies to government's collection of location data from wireless carriers, but the person who is up for nomination, Mr. Barr, has not been willing or finds it important enough to even read the Supreme Court decision on this case. The government's collection of business records is authorized by Section 215 of FISA. That's part of the Patriot Act. There's serious concerns about 215. Abused for years to carry out a secret program that swept up the phone records of millions of innocent, law-abiding Americans. Even after the USA Freedom Act, which was intended to end bulk collection, it's been used to collect hundreds of millions of phone records. All the government needs to collect these records is to show the FISA court that the records are relevant to an investigation. No requirement for a probable cause warrant. This important law sunsets this year, so the Congress will have a debate about whether these authorities are too broad or whether there is a need for more checks and balances. I see my colleague from Texas also serving on the Intelligence Committee. We're going to have a debate about it. That's the way it ought to be. Today, we're talking about what I consider to be dangerous views espoused by Mr. Barr. And what Mr. Barr believes is the government shouldn't have any court oversight at all when it comes to collecting the records on Americans. He thinks that the government should just unilaterally issue a subpoena and collect those records, and there would be no oversight whatever. The foundation of Mr. Barr's beliefs when it comes to surveillance is the president can do whatever he wants if he believes that national security is at stake. So I'm going to close by simply talking for an additional minute or two about what this means if Mr. Barr is confirmed as Donald Trump's Attorney General. The president is right now openly considering a declaration that he, Donald Trump, has emergency powers to override the will of the Congress, and he is doing this while relying on a baseless assertion that there's a national security crisis. Until he was fact-checked, he was making really far-fetched claims about terrorists coming over the border. He also regularly calls journalists enemies of the people and calls for investigations of his political enemies. I would oppose the nomination of anyone with William Barr's views on executive power, regardless of who was president. But the kind of threats I'm talking about are too serious to ignore. Donald Trump has openly said, and said specifically, how much he would enjoy unchecked surveillance power. During the 2016 campaign, when the Russians were hacking his opponents, and I want to read this, the President of the United States, our current president, said, and I quote, "Honestly, I wish I had that power. I'd love to have that power," unquote. So if Donald Trump decides that national security is at stake and William Barr is his Attorney General, it would be Mr. Barr who might give him that power. Power he could use with no oversight from the courts and without regard to what Mr. Barr has dismissed as our laws, the schemes that he has described the laws of the Congress. And in case anyone thinks that Mr. Barr would himself serve as a check on the president, he's also written that that is not the job of the Attorney General. Just last year, he wrote that all executive power rests in one and only one person, the president, and the president doesn't have to convince his Attorney General that his orders are legal. So, Mr. President, let me be clear. The issues that I have raised with respect to Mr. Barr's views on surveillance are not kind of conjecture or possible theories. What I have been talking about this afternoon are the views outlined in Mr. Barr's own testimony. I hope that every member of the body will take the time to read what Mr. Barr's testimony has stated and consider what's at stake. There are members in both political parties in this chamber who've long been concerned about the expansive surveillance authorities under the Foreign Intelligence Surveillance Act or the possible abuse of that law. Those concerns are, in my view, small potatoes compared to what Mr. Barr has proposed, which is that the law need not constrain the president whatsoever. For example, some members of this body have expressed concern about Foreign Intelligence Surveillance Act warrants in connection with the Russia investigation and whether all relevant information has been provided to the FISA court. Consider a world in which the government doesn't need a warrant and doesn't have to justify its surveillance to any court. Consider the possibility of abuse in that world. That is the world that Mr. Barr has testified that he wants. I also would appeal to my colleagues with whom I've had some pretty vigorous debates over the years about surveillance and who may have had no concerns about the current framework of our laws. We can have our disagreements about how to write the law. We do here in the Senate agree that the laws passed by the Congress mean something. They are binding, and they are not, as Mr. Barr has stated, schemes that the president can just ignore whenever he feels like it. This nominee has been more than clear about where he stands. He believes the president alone decides when there's a threat And when he does, he doesn't have to worry about Congress, judges, the laws, or the Constitution. In my view, that is a prescription for trouble, a prescription for more abuses which Congress may or may not even be told about. But we've been warned. We have been warned by Mr. Barr's testimony. Mr. President, I'd also like to note that I have concerns about Mr. Barr that relate to classified matters, and I am currently seeking declassification of those matters and hope that this will be resolved prior to any votes on the nominee. I see colleagues are waiting, and Mr. President, I yield the floor.